So let me officially welcome you to HIPAA and Technology. I appreciate you coming here this morning to spend a few hours dealing with HIPAA. I am not here because I love technology. I am not here because I feel particularly proficient around technology. I'm certainly not here because I love HIPAA. However, along the way, I have encountered some resources and some information that I have found to be actually reassuring and helpful. So I wanted to have an opportunity to share that with the rest of us, because we all have enough to do with the work, that anything that can be done to help support and simplify what we need to be doing for clients is always time well spent in my mind. So let's get started then.
Would you like me to close the door?
Let's leave it open for airflow. It's pretty quiet so far. Thank you.
Bye-bye.
All right. I have to have the statement here, which actually is important. Each of you have a very individual practice format, different populations that you work with, and this workshop is in no way intended to substitute for legal advice or for whatever specific structures you might need in your practice. Offer general information, and then you're free to use that as you see fit for yourselves. I don't know if this sounds familiar to the rest of you. Computer says I need to upgrade my brain to be compatible with its software. And I wished that this was how tech support worked. Go to the preferences file, click on the pull-down menu, find the option that says nothing works right, and uncheck it. Yeah. If I may. And one of the things that I've encountered that's really interesting, there's a description now of two classes of people dealing with technology. The first class is called the native class, and the other class is called immigrant class. Natives tend to be younger people who have grown up with technology as a part of their lives. Immigrants, I classify myself as an immigrant, are people who didn't grow up with technology, don't find it to be comfortable or their first language, and yet have to acculturate to that. As a professional, it's really challenging to be an immigrant and have to do all of that adjustment. Many of my clients are natives and want to use their technology as a part of the counseling process. So that is another reason that HIPAA becomes very important here. In actuality, mental health has been one of the best areas for protecting client confidentiality and privacy of anything. If we go all the way back to actually the Hippocratic Oath, which is the beginning of the medical profession, we can see that whatsoever things I see or hear concerning the life of men in my attendance on the sick, or even apart therefrom, which ought not to be noised abroad, I will keep silence thereon, counting such things to be as sacred as secrets. So, all the way back to the beginning of our tradition of caring for people, we are mandated to protect confidentiality. HIPAA was originally created in 1996 as a response to health insurance and to all the patient information that was being processed through health insurance companies, which in fact were not regulated with information at that point. Good morning,
So
welcome.
lost.
Easy to do. All right, as we go through our morning, I have created something that I hope will be useful and fun. We are going to have a Smarty Pants game, and the winners are going to take home the prize. So if you would partner with the person next to you. Darcy, you can partner. And
Catherine.
I don't know you, Catherine. Nice to meet you.
Absolutely.
Actually, I've had you in class.
I'm sorry. Good. Good. All right. So, as a team, we're going to have questions as we go along. And you want to confer as a team and answer the question. If you get the answer right, you get chocolate. So, question number 1. What does HIPAA stand for?
You heard my attempt. Okay.
Do you agree with
Yes.
It's Brittany, right?
Yes.
I get so confused because Brittany spells in a different way. Yeah.
All right. Belinda and Brittany think they know.
It's the Health Information Portability and Accountability Act.
Oh, very good. Yes. Yes, that's exactly right. Health Information Portability and Accountability Act. Anybody else get it? All right. Catch.
Thank you.
Flying chocolate.
Okay.
All right, yes. So, health information portability, that refers to how information is transferred from one place to another, which it is a lot these days. And then accountability is that we have to treat client and patient information as carefully as we treat our clients. If you don't take away anything else from our time this morning, that's a key to take away. The information is as essential as the client. Health Information Portability and Accountability Act, originally passed in 1996. In 2009, the high-tech amendment was added. Then in 2013, a final ruling, which is called the Omnibus Rule. You'll encounter that a lot. The 2013 Omnibus Rule tightened things up, made several changes, and that is our guidance currently, is that 2013 rule. All right, here's question number 2. Which entities address patient privacy and confidentiality? HIPAA, ethics codes, Colorado law, or other federal laws? Any or all? This is a team question.
Uh-oh.
So you confer with your
No,
team.
we already did.
They conferred, they're ahead.
Okay, let's give a minute for the other teams. You guys are fast, you're reading it. Boy, there's a lot of smarty pants competition in this room. Okay. What do we think? You get to go first.
All of the above.
Correct. Absolutely true. Did you all know that? Okay, so here comes a lot of flying chocolate. Get ready. Oh, jeez.
Hey there.
Lisa, get ready.
Hey, finders keepers.
If you don't trade out one of mine,
Sure.
Okay, yes, yeah. In fact, interestingly, the National Association of Social Work Code of Ethics specifically states that social workers are mandated to follow HIPAA guidelines. Our Code of Ethics for the American Counseling Association specifies that we need to take reasonable precautions to protect the information of clients. And there is a statement in every ethics code for every one of our professions regarding privacy and confidentiality of records. Colorado law, our revised statutes stipulate that failure to protect the health information of a client is an offense and actually a felony. So we break a Colorado law by not following our HIPAA guidelines. And then our other federal laws, some of you might know about FERPA, which is the Federal Educational Rights Privacy Act. That governs school systems and colleges. And there are standards in that as well. Also, federal law is how malpractice and negligence are determined. In a minute, we're going to talk about who is bound to HIPAA and who is not. Actually, why don't we do that at this point? Question number 3. Does HIPAA apply to all mental health professionals?
Let's say yes. If not, it should be. That's medical.
Okay, so everybody thinks yes? Actually, you are all right. However, there's a little interesting nuance here. Technically, HIPAA states that it applies to anyone who stores or transmits health information to patients
That would include your.
electronically. So if you only keep paper records, if you never communicate with clients through any electronic means, if you only send papers through the mail or via a secured fax line, HIPAA doesn't apply, according to HIPAA. I don't know anybody who doesn't use technology in the course of either creating or communicating records to other people. So hypothetically, it's possible.
But if you're keeping paper charts, aren't you storing them?
But not
But-
in electronic form.
Not in electronic form.
Okay.
Right. The other piece here that's really important is that HIPAA has become our standard of care in the field. And if we don't practice according to standard of care, then we are open for grievances. We could possibly get sued for either malpractice or negligence. Bottom line, for all intents and purposes, HIPAA's here, and we really need to be compliant. The good reason for doing it is because it's important to clients. In addition, it's required. The HIPAA verbiage talks about covered entities. So you're either a covered entity through HIPAA or you're not. And if you're a covered entity, you're a health plan, you're a healthcare provider that does transactions in electronic form, or you're a healthcare clearinghouse. We're going to talk about business associates a little later on here. That was one of the changes in 2013, and it's a very significant one. So if you hear this phrase covered entity, it's HIPAA's way of designating HIPAA applies to you. Oops, that's backwards. There we go. So, here's what we're not going to talk about today, and there's a lot. In 2.5 hours, I really only want to focus on the technology and the security aspect of HIPAA. In 1996, the original privacy law was passed. That didn't have very many electronic stipulations in it, because at that time, we weren't using technology that much. Amazing how things have changed in the course of about 20 years. We're not going to talk about all of that. It's a lot. There are a lot of privacy regulations. If you want to talk about that at some point, let me know, and I'll set up a time to do it. In 2009, the HIPAA Act was passed. That added this security piece to what was already present from 1996. We are going to talk about that today. I'm going to cover here in just a minute some information about breach, notification, and enforcement. That was added in 2013 in the omnibus rule. This is the big picture. This is what we're focusing on today, security aspect. So high-tech health information technology for Economic and Clinical Health Act. It really doesn't mean, hey, it's time to end your compliance holiday. So in 2013, 3 changes. Stronger enforcement for violations, bigger fines, and wider application to more agencies and entities. Much of this is geared toward health insurance. Prior to 2013, 2009, health insurance companies were not required to do many of the things that are so essential to protect client information. Have you had the experience, which I have, of a client not being able to get health insurance or having to pay excessive amounts for health insurance because of pre-existing depression or anxiety or other mental health condition? Before these tighter standards, health insurance could take their patient information and share it with other companies. And so the patient didn't even have to disclose to the insurance company about their history. It was available through this database from insurance companies. Good thing for this rule. Also in HIPAA, just so that you know, are 5 number codes, 90834 for individual therapy, 90847 for couples. That is HIPAA. That's prescribed by HIPAA. So there haven't been any changes to those since 2013. But there were changes in 2013. Those are called CPT codes. And those are required for insurance reimbursement. Do you all have a national provider identification number? That was also required in 2013. I appreciate that a lot because prior to that, my social security number, which was my identification number, went out on my billing statements, which I did not like. It wasn't identified as such, but it went out there. So this is a much better system for our privacy. I'm going to briefly talk about enforcement and breaches, and then we're going to go to security. I keep going backwards. All right. So 2013 established 4 levels of accountability. This is the beginning of some really good news here. We, as small providers, are not held to the same standard as hospitals and large corporations. The expectations are that we take reasonable precautions, and that's actually in the HIPAA law, the word reasonable. That's the first of good news. The next part of the good news is that if something happens and we were not aware that it happened, that is a lower level of breach. So basically, mistakes are allowed. The next level, if we had cause to know, but didn't know. So made a mistake, didn't know, but should have known, that's the next level. Third level up from that is, I knew I should have done it differently, I didn't do it differently. That's called willful neglect. Last level, willful neglect, no attempt to correct. There's an interesting example of this. Let me make sure I get you the specifics here. It was a large hospital that had a breach of client records. The federal government came in and they tried to cover it all up and wouldn't cooperate with the audit or the investigation. They were fined $1.3 million for the original breach and $3 million for their willful attempt to resist and avoid the outcome. Yeah. So, how you handle what happens makes a really big difference. So 2013 established these guidelines for fines. So we can be fined from $1,000 all the way up to millions of dollars, depending upon the nature of the breach. Jail terms. 1 year in prison for some offenses, 5 years in prison if things are committed under false pretenses, 10 years in prison if the offenses are committed with the intent to sell, transfer, or use PHI for commercial advantage, personal gain, or malicious harm. Do any of you know about the IRS scandal with identity theft? Have you heard about that?
Mm-mm.
This is very interesting to me. Recently, there has been a wave of identity theft that's happened through the IRS. Staff at medical offices are taking patient information and selling it underground to the scammers. The scammers then take the information, file a tax return using that information. The IRS issues them a refund, because the IRS doesn't check. Then, when the actual person files their taxes, the IRS says, we already gave you the money. And if identity theft occurs, it falls on the victim of the theft to prove that they are who they say they are. It is a problem that has wide-reaching implications. Credit report, any kind of loan, your bank accounts, and it takes years to clear up identity theft.
Is that why this year for Colorado, they were mailing out paper checks as opposed to direct deposit because of the theft, or identity theft?
It may be. The IRS issues a plastic card if you want it. And so it's like a gift card. And they issue it, and then you just use it like plastic. And so the scammer has the card, doesn't have to prove who they are at all, and just uses the money. Yeah. So if those people are caught, this law is how they get prosecuted. That's good news. There are certain exclusions. Okay, back up. A breach occurs when protected health information is accessed by someone who doesn't have the authority to access the information. That's the definition of a breach.
Can you say that again?
A breach occurs when protected health information of a patient is accessed by someone who does not have permission or authority to use that information. That's a breach. I'm about to give you some more good news. There are exceptions. There are certain cases where a breach is not actually an offense. Here they are. So the first one is, if my laptop is completely encrypted and has client information on it, and my laptop gets stolen, whoever has it has no access to anything on that laptop. So that's not a breach, even though the piece of equipment got stolen, okay? Encryption would be another great thing for you to take away this morning if you don't take anything else. Encryption is our best friend across all devices to the extent that it's possible. We'll get into that a little bit later on. Okay, disclosure of a limited data set. If the only thing that gets disclosed is a person's first name, that's not considered a breach. So my appointment book has first names in it. Heaven forbid something happens and somebody gets their hands on my appointment book. That's not considered a breach because there are 55,000 Susans and Jims and first names in the world. Okay? Limited data set. Unintentional acquisition, access, or use by a CE or business associate, BA, business associate, workforce member who is acting in good faith and does not further use or disclose the PHI. Wading through this language is so fun. So here's an example of what this is talking about. I have 4 associates. We have an automated phone system in which we each have an extension. Every so often, one of my other associates' clients will leave a message on my voicemail by accident. And so what I do is take that and give the information to my associate. So that breach happened. I got the information, but I'm a business associate of all of my associates, and I'm a covered entity. So I got the information, I'm a covered entity, VA, I used it, no harm was done. That's what that's talking about. This one? And actually my example fits here too. So this would be the situation in which it's somebody within an organization and they inadvertently get the information and it doesn't go anywhere else. Now, if I were to take that phone message and call the client and their mother answered the phone and I said, I would never do this, but hypothetically, and I said to the mother, oh, so I got this phone message from your daughter and she said da-da-da-da-da-da, so could you please pass along to her ABC? That's not an exclusion. That's a breach. Yeah, it's kind of an interesting thing. So if the information somehow gets into someone's hands and I know that they're going to destroy it, then we don't consider it a breach. So this happened. I received an email that actually was intended for someone else, and the person who sent it realized that it had happened. I destroyed it, no harm done. That's what this is talking about. Good faith belief that the unauthorized recipient would not be able to retain it, or didn't. Does that make sense?
Is that where the disclosure on the bottom of our emails comes in and faxes?
But actually, email is a little more complicated in that regard, but yes, if the recipient of that email was another professional and we knew that they wouldn't keep the information or do anything with it, then that's under this qualification.
Is there a section where we talk about financial information of clients?
Interesting thing about financial information, it's exempted.
Huh.
This is helpful.
Yeah, so any information we get in order to collect our fees isn't considered protected health information. So all of our bank records, if you use a card reader, which by the way, Square is not HIPAA compliant. I mean, I haven't just said that. Okay, that's a contradiction. There are some problems with Square that have to do with privacy of information. One of them is, if the client provides an email as a part of the transaction, then Square will send them a request to evaluate the provider. That is a breach of HIPAA. And it's a breach of our code of ethics because we do not solicit endorsements from clients. We don't
So then if
solicit testimonials or any kind of review from clients.
So if they just don't give their email, then it would be fine.
Yeah.
Like a text,
Um,
because a lot of
but
them text the
I think they,
receipt.
Does it
But
ask
I
how do
think
you
they
want your
still
receipt by
get-
email or text?
they still get the request from Square through text message.
Mm-hmm.
So the text wouldn't solve that problem.
I just wouldn't do either.
Right. No receipt.
But like Intuit doesn't do that, is what you're saying. The company Square has that process, but
Exactly.
Intuit doesn't have that process.
I'm not as
As
familiar
far as
with
you know.
Intuit, but
Oh, okay.
I think you're right about that.
Oh, okay.
I don't believe that they do that. PayPal does not do that. PayPal is very secure. So I certainly recommend PayPal.
So, for example, when I take checks from my clients with their full names on them to the bank, and the bank teller has the names of my clients that wrote their checks to
Yes.
Haven Lighthouse,
Mhm.
then that's okay.
It is okay. That's exempt.
Isn't that interesting?
Anything related to banking.
How could it not be?
Right.
I know, but
Wouldn't
it's,
that be?
we have to protect our address book, but the bank tellers can have it.
Exactly.
I just think that's funny.
And our banking institutions are not regulated by HIPAA
Oh,
in any way. It doesn't apply to them. In fact, many regulations don't apply to banking institutions.
Hence.
All right.
Thank you.
What to do if there's a breach? If it happens, there are certain steps that need to be taken depending upon certain things. If I would quit going backwards. If you see fewer than 500 clients at a time,
And it's fun.
At a time,
uh-huh,
in a day?
That's a hard day.
no,
in one
on your
moment.
caseload,
For example.
I kill myself.
So HIPAA divides small practices and large organizations and practices at the 500 patient line. So if you have, and Brittany, your organization may have 500 people getting services at one time, you're considered a large organization for HIPAA purposes. The fines are much stricter. The results are much more grave for larger institutions than for solo practitioners. As a matter of fact, since 2013, there have been no known cases of the Office of Civil Rights that administers HIPAA doing anything with a solo practitioner.
Well, since when?
Since 2013, when these rules were enacted. So if we are smaller, if the breach involved fewer than 500 patients, we don't have to notify the media. Remember Target? Now, Target is not HIPAA covered, but Target had to notify every social media, advertising, really had to get the word out because of the enormity of that breach. If it's a hospital, they'd have to put a notice in the newspaper, they'd have to send notice to every one of their patients, and that has to be done through media. That's not us, okay? That is not us, because we're not 500 or more. We do have to notify the client if there is a breach. The client has to be notified. And HIPAA has to be notified. The Department of Health and Human Services is the big government agency that oversees HIPAA. The Office of Civil Rights is the specific department that deals with HIPAA. So it's the Office of Civil Rights that we notify when there's a breach. And I put in your packets a breach assessment form. This notebook has a forms packet for HIPAA that I put together for you that I thought might be useful. Let's take a look at it. The blue sheet divides the first half from the forms. The breach assessment is in the second part of your forms. The first part of the forms consists of forms for clients. The second part of the forms, which start on page 26, are forms to assist with HIPAA compliance. Okay. The breach assessment form is on page 32. So this gives you all the things to think about if there is a breach that occurs. The nature of the information, who got it, is there a chance that the person that got the information will keep it? And how was the breach handled afterwards? And then the second page outlines some of the things we've been talking about. 500 records or less. With the exemptions, there's no specification that the client has to be notified. So if my laptop gets stolen, I don't have to tell all my clients that my laptop got stolen. I could. The greater good is my consideration with ethics. Will it in some way interfere with my work with the client if they don't know? Will it be helpful for them if they do know? Those are things to consider, but it's not spelled out. If the breach happened and we determined that there wasn't really any harm that occurred, then the notification would not be required. So in the case I mentioned where I got the voicemail message from my associate, didn't hurt the client, didn't cause any disruption in their care, so the client and OCR didn't have to be notified of that one. Safe harbor actually comes from the techie world. Safe harbor is encryption. Anything that gets stolen that is encrypted falls under safe harbor and is not considered a breach. It bears repeating. Anything that's encrypted that is stolen or accessed in any way inappropriately is not a breach if it's encrypted.
I have a question about the breach. You know, when we're talking about protected health information, it becomes breached because we're having it and somehow it gets disclosed. The voicemail example that you're talking about is the client is doing something, right? She left a voicemail.
Yeah.
And just like clients can say, oh, my therapist is blah, blah, they're free to say anything about themselves.
Mm-hmm.
So I'm a little confused about how that was a breach, even though the therapist had nothing to do with revealing
Great question.
anything.
That's
right?
a great question. It's a breach because technically our voicemail system at Integris didn't protect her from that possibility. So Integris committed the breach because the voicemail was confusing for that particular person. That falls in the inadvertent category or the reasonable category. You can't have a voicemail system that isn't confusing to someone somewhere along the line. But your point is very well taken. It's not a breach. If a client puts an ad in the newspaper and says, I've been working with Stacy Blank, she's the most wonderful person I've ever met, and you all should see her. Clients can do that. Also, they can go to the wonderful websites that list all of us and write reviews. There's nothing we can do about that. They're free to say anything they want on any of those review sites.
We just can't solicit, which is the problem with Square.
That's right.
Okay.
And the problem with websites, and I've seen it, I've seen people who have client testimonials on their website. It is not ethical. Well, because think about it. If I ask a client to do a testimonial, I'm wanting them to do something for me that helps me. That shifts the relationship from me being available to them being obligated to me.
What about,
So it's a burden.
what about in the case of a nonprofit? Is that the
Same
same
thing.
standard?
It's an ethical standard.
Because I have seen that on a nonprofit
I
recently.
know.
So that applies even if the counseling relationship has been terminated and the
Yes.
client's no longer coming in for services?
and that's a little bit gray. How do we determine whether the relationship has ended? If it ends and then they come back 3 years later, was it ended or was it temporarily not happening? Yeah.
Would that apply to unsolicited remarks that were, say, given to you somehow? You still couldn't use them for any sort of posting purposes?
That's right. And we want to think about what happens when it gets posted, too. Number one, what happens to that client? Suddenly they're online as connected with you. And I know it would just be the first name, but there's still that public alliance that's a part of the client's experience. Also, what happens with our other clients when they go and they see, here's a, excuse me, here's a testimonial from one of the clients. Oh, well, I guess she likes that client a lot better than she likes me because she never asked me to write a testimonial for her. And so there is that kind of consideration. Ooh, makes sense?
Random question. If someone who was not your client wanted to put a testimonial about you and your character and personality and type of work, is that not covered because they're not under your client?
Yeah, and
Scenario.
you can have a colleague say all manner of wonderful things. You can have 25 colleagues talk about how wonderful you are.
Let's all go work on our websites.
Or you can make stuff up.
Yeah, right?
So this is considered under the health information, privacy of health information. So my dentist is the best in Will County for the last 10 years or whatever. Wouldn't that fall under the same idea?
And here's, testimonials and review sites are not actually a part of HIPAA. They're part of our ethical and legal considerations. Because the client is disclosing the information, as opposed to us or someone who's not supposed to disclosing the information. Yeah. Important point. Several things all play into this, and it's a challenge for us because we have to know Colorado law, ethics codes, HIPAA, federal regulations, and get on top of all of it.
So what if you're
And see too
nominated?
many clients.
What if you're nominated for best counselor?
I know.
Congratulations. If that's a thing, how do I get nominated?
That presented herself as best of her city.
Wow.
Yes,
Wow.
Boulder actually does that.
Oh my gosh.
I don't know how they come up with that, but they have a best therapist award that they give.
Are you serious?
In Boulder.
Oh my goodness.
We're gonna have to edit that out. I don't want to be offensive to anyone.
It's actually like the, some of the littler newspapers and like the 5280 thing.
Oh, yeah? Uh-huh.
People submit who they want and then they make a big list and then people vote.
You're the best.
And again, a solicitation that would come from a review site online or one of those publications wouldn't be us committing a breach. They can pretty much do whatever they want. And then the patient responds however they wish to. I put a social media policy in your packet, and we'll get to that a little bit later on. I think that it is an ethical consideration, regardless of whether it's legal or illegal, when clients are doing testimonials or reviews. If a client puts a really bad review on a website during the course of therapy, why aren't they talking to me about it? And I need to address that. All right. We've been talking about breach notification. We're going to move on now to talking about security. We are going to launch into our discussion of the security aspect of the omnibus rule. There are 4 important considerations here. This would be another takeaway from our time together this morning. If you keep these 4 things in mind, that will guide everything else that happens. The first of those is But HIPAA is designed to ensure the confidentiality, integrity, and availability of protected health information. So 3 things. Confidentiality, meaning it does not get accessed by anyone other than you or people involved in the treatment of the client. Confidentiality. Second part, integrity, AKA no computer crashes. I hope that's never happened to any of you, that you've lost all of your data because your computer crashed.
Just in grad school.
One of my friends,
Oh, gosh.
yes, I had that happen to students too. They had their paper almost done and their computer crashed and had to start completely over. They needed an extension, obviously. One of my friends was drinking a chocolate shake next to her laptop while she was working, and the shake spilled and went inside her keyboard and into her computer. Gone. She had to get an entirely new computer.
So what happens, like, if the data could crash but still be recovered? If you
Yes.
take it somewhere?
Yes. And so backups are crucial
Okay.
as we're talking about preserving integrity. Back up your computer regularly in some way that's not inside your computer.
So what about the cloud?
Cloud, depending upon which service it is, cloud has to encrypt your software or encrypt your data, or it is a business associate and you have to have a contract and all kinds of specifications for that. Here's another takeaway shorthand thing. Hire an IT consultant, really. I am very blessed to be married to one. It's really, really helpful. I think most of us have CPAs, most of us have attorneys, and really having an IT consultant will just save so much time and headache with all of these considerations. Because your IT person can say, here's the cloud backup that you should use. They're encrypted, not a BA. They can sort through all of that. Who has time, right, to figure all of that out?
I also have a hard drive backup, or
Yeah,
that's what I've been using,
Mm-hmm.
so you can get just little like hard drives that are like 4 tetrabytes or whatever for like $50 or $60 and take them wherever.
Yeah, I have a portable hard drive, so I could back up my computer on that portable, and then the portable stays in my file cabinet, locked with my files. That way, anything ever happens to my computer, I still have the backup. I use iDrive, cloud backup. They are encrypted, so business associate agreement is not required. iDrive. Also, because when I got it, they were having a sale. It was $15 a year. So
Oh, wow.
$15 a month. My bad. $15 a month. So
So if you
many
use-
others are 60 or 70.
So if you use a tech consultant person,
Mhm.
then you'd actually have to have a business agreement, a business associate agreement
Yes,
with
you
that
do.
person.
You do.
So you can't take your
Yes.
stuff to Geeks Club?
That is correct.
Okay.
Okay. We'll talk about business associates a little bit more in depth in a few minutes here. Okay, so that has to do with the integrity of the data. We don't want their information to be compromised or, God forbid, deleted. The next thing is availability. If a client requests a copy of their records, we have to provide it. That is a HIPAA requirement.
Where does
If they
the
request it-
therapy notes fall into that?
Psychotherapy notes are an exemption. This is such a gray area. I heard an attorney recently state that even though this is how things are written, it won't hold up in court. The idea here is that as therapists, we can keep a separate set of notes, which are personal notes that we make for ourselves about the process of therapy for the client. If those notes are kept in the file with the client record, they become a part of the client record. So if you're going to keep those, they have to be separate from the file.
I was always told you couldn't have separate files.
Psychotherapy notes are the thing. They're an exception.
And this is an ethical issue. But
This
it's
is
also
HIPAA. HIPAA
okay.
specifies
Ah.
that psychotherapy notes can be kept separate from the record and do not have to be released
Right.
with the rest of the record. Our legal mandates also allow for psychotherapy notes. Other than that, I missed it.
I said I think I might get a different job.
Well, be reassured. Anything that happens, we are small potatoes compared to these big pictures. First of all, HIPAA has not come to look at a solo practitioner yet. So they're probably not going to. Don't put that on the table. Secondly, if they do, and we're making every reasonable effort to be compliant, they're going to say, you probably should change this, and that's it. So really, it's okay.
They're not out to get us.
Yeah.
So can I clarify it?
Absolutely.
So there's the client medical record, and then there's our personal notes.
Uh-huh.
And if the personal notes are kept in the client record, it's considered the actual medical record, and it can be subpoenaed, and it must be protected. If we keep them separate, they still have to be treated with the same confidentiality, but just in separate places
That's right.
to not be
That's right.
the medical record.
That's right. And the client cannot access them. Clients can't get our psychotherapy notes,
Yeah, okay.
nor can the court.
As long as they're not part of the record.
That's right.
Okay.
That's right. Anything that's in the record is considered part of the record. Okay. Integrity, confidentiality. Third thing, availability, meaning we have to be able to give them to clients whenever they ask for them. And if they ask for them electronically, we have to give the records to the client electronically.
So would
That's
that,
a new HIPAA.
would that mean if it's a handwritten record that it has to be scanned then?
It does.
Can we charge the client for it?
Yes.
You can charge the client for it, but you can't charge the client excessively. There was one case where the hospital tried to charge the client $100 for records, and HIPAA came in and said, no, that restricts their access. $30 is what I've seen, somewhere between $15 and $30. Put it in your disclosure statement. And it's in the HIPAA form also. Confidentiality, integrity, and availability of records, first thing. Second thing, protect against threats or hazards to the PHI. Encryption, where you store your computer. Do people have access to your computer in the waiting room? That all has to do with protecting access. Third thing, protect against any reasonably anticipated uses or disclosures not permitted or required under the PR, legalese, which basically means make sure that you don't accidentally get somebody's records in the wrong place. I have an assistant receptionist. It's important for her not to work on client content when there's somebody in the waiting room. That would be an inadvertent access of that information. Fax machines have to be placed properly so that clients in the waiting room can't see what comes in through the fax machine. Those are a couple examples of this idea. And then workforce. Okay. Workforce is anybody that handles your client information for you. Your assistant, your receptionist, one of my colleagues has a CPA that does all of her deposits, and so he sees all the client information. That's a workforce. Your IT person, anybody that works for you and has access to client information. Those people are business associates, and there's a whole structure for that we're going to talk about in a minute.
So would that include if people aren't actual clients yet? For example, we have a central phone number where people can leave a voicemail and say, I'm interested in therapy, blah, blah, blah. And one of us gets that and then, gives them 3 numbers, whatever. Is that under this what you're talking about?
You all would
That
be
we're a
business
workforce.
associates,
Uh-huh.
and you're a workforce together.
Mm-hmm.
Mhm.
Okay.
Mhm. Yeah, and that's where each of us has kind of a specific setup. If you're set up as group practice, then by definition, you're all work associates. If you share office space but don't share anything at all, except the room, then you're not a group practice and not considered business associates. If you share a common phone, you're business associates.
If you have an assistant that only handles financial information, do you have to go through the BA process?
No, anyone that doesn't have protected health information is not a business associate.
Cool.
Right. Yeah. So your attorney, your accountant that just does your taxes and your basic expenses and income.
But your medical biller does get that information.
Yes, right.
Because we have a CPT
Yeah.
codes.
Mm-hmm. Your billing company, absolutely. All right. Those are the general guidelines for the security rule. Now we need to get into some specifics. In case you have questions about what's electronic, I think it's pretty obvious. It's anything that's transmitted by electronic media or maintained in electronic media. So, I don't bill insurance directly, so I don't transmit information electronically from my computer to the insurance companies, but I maintain information in my computer. So all of this applies because the information is stored in my computer. There are a couple of exclusions. Educational records. These have to do with school nurses. They're kind of in a whole separate category in terms of records and what gets done. And then employment records involving an employee and an employer. So these things don't apply to us. Does anybody not store or transmit information on clients electronically? Ever at all? You have nothing in your computer about clients.
Not that has any, okay, so that's a question, not that has any last names. There's nothing with any last names. So if I have something that has only a first name on it.
The records are all pen and paper.
Mm-hmm.
And how do you give records out to other people?
I don't. Who would I give records to?
Physicians, patients.
I haven't had to give
Okay.
any records.
Well, then you don't need to be here.
Oh, I have texting questions.
So you
Well-
do handle client information,
So if-
stored or transmitted.
Okay, so
Oh,
those
so
those are
email.
part of the record.
Great question. A communication that comes from a client through electronic media is also covered by HIPAA. It's considered protected health information. I keep saying records, but it also does include communications.
Okay.
Yeah, good clarification. All right, here's your good news in case you want it one more time. The security rule says that we can exercise flexibility and that we are expected to do what's reasonable. It is probably not reasonable to pay a consultant $5,000 to come in and completely ensure that we are HIPAA compliant in every single detail. Maybe you want that $5,000. So reasonable means what is economically feasible, what matches with our level of risk as we use information. That's good news. And appropriate. Reasonable and appropriate. As we go through the standards, there are certain standards HIPAA has set that are required. You have to do it, no exceptions, this is the deal. There are other standards that HIPAA calls addressable. That means that they want us to consider the standard, and if we can't meet it or if we make some adjustments, we have to say what we did and why. Standards are either required or addressable. We'll go through those as we go. 3 ways that we have to safeguard the information. First of those is administrative. So this is my desk.
Yep.
I got somebody else to sit in front of it to take pictures. It's only how I feel. It's not really nice. But the first consideration here is administrative. Let's talk about that then. If there is some kind of HIPAA action that is being taken against us, we have to prove or disprove the violation. And that comes back to paperwork. Paperwork. We have the burden of demonstrating that everything was done to notify people of the breach. Or we have to say, this happened, but it wasn't a breach, and document that. Or we have to say that it really wasn't enough information to cause any kind of risk, AKA first names. That all needs to be documented.
Where do we put that?
Good news.
In the client file or?
I made a form.
There's 4 things.
Actually, we have to keep a HIPAA file of all of the structures that we have to have in place. So, I like notebooks, as you can tell. A notebook is a great way to keep a HIPAA file. In your forms packet, there is on page 29. A risk assessment form. Bad news is we all have to do a risk assessment for our practice. Every one of us. Good news is this is a way to do it. This is simplified from the actual HIPAA system. The National Institute for Standards and Technology has created a risk analysis system which has 472 questions. Yeah, it applies to hospitals, health insurance corporations, where there would be 472 things to consider. Does not apply to us as solo practitioners or even as a group. So this risk assessment form is for places with fewer than 500 clients. And I'm sorry that doesn't necessarily apply to you guys. There are 4 steps here. The rest of what we do today is going to go through this form. So when you leave, you'll have most of this form. This then becomes the document of you having performed a risk analysis. When you complete this document, it's your record of your risk analysis. For today, now that needs to be updated and it needs to be considered on an ongoing basis. But at least it's a starting place. All right, it's time for some more smarty pants questions. And then we'll get to this one here. This is the recent journal from the American Counseling Association. Very interesting. There's an article here on technology and texting in particular with clients. So these are statistics questions. In 2010, what % of people said they'd rather communicate by text than phone, even with people they knew really well? These are team questions.
Do you have to put up a number?
Guess a number, yeah.
Okay.
So that, what year is this?
2010.
I would go even higher.
Because I know I would.
All right, what do you think?
You said 70%.
70%?
We said 75.
Okay,
I think like 85.
okay,
Oh, we were thinking 30.
okay.
85.
According to this time poll, it actually is 32%.
Oh my
Oh, you guys are right. There you go. Oh,
It was, like she pointed out, that was like 5 years ago.
Right,
Yeah,
exactly.
that's
5 years ago, that's what we thought about.
And 5 years is a long time when it comes to technology, right? Okay. All right, smartphone owners, ages 18 to 24, receive how many text messages per month? Uh-huh. Smartphone users, ages 18 to 24,
Yeah.
get how many
Yeah.
text messages per month?
Now, like, it was like currently, what?
5,000 or 6,000.
Currently is it?
Send and receive.
Per month. Per month.
Per month.
Yeah.
Yeah. They're getting.
Yeah, I agree.
I don't know.
Even more.
All right, let's start on this side this time.
3,500.
Okay,
8,000.
8,000, okay,
I was thinking 1,000.
1,000,
5,000?
5,000.
6,000.
The actual number is 4,000.
Oh.
Send
We were close.
My girls are.
You guys are close.
Your girls are outliers.
So they were.
What
All
was
right,
it
okay.
for?
Oh, well, I guess nobody got it exactly right.
3,500.
That
Maybe
was
we get chocolate.
They should get All right. All right.
She did the math.
You guys
She
get
deserves
chocolate.
chocolate for doing the math.
Okay, let's take a look at this form here. On page 29, we have step 1. And I will give you the choice of whether you work with this on your own or whether you work with this with your teammate. There isn't any chocolate per se. Your reward for working together is the relationship that you build.
Oh, wow. Yours is a therapist.
So you need to consider 4 things here. The first is how and where do you do your client records? Are they paper and pen? Are they in your computer? Does anybody use one of those therapy helper software package programs?
I used to, but not now.
Okay, yeah, there are a lot of them out there. Many people like them because they really put everything conveniently together. Put the information in and the program takes care of all the different forms. Okay, so how do you do your client records? Second thing, once you create the record, how does it get stored? Does it go in your file drawer? Does it go on your computer, on your hard drive? Is it on your desktop? Did you put it, I have a colleague that uses a thumb drive. Number 3, how and when is PHI transmitted? Fax, email, snail mail, in-person pickup? And how and where do I receive PHI? Fax, scan, snail mail, in person. Okay, so just start by making a list. So think about an average day with clients. And go through what you do with the information. So I'll give you all chocolate no matter how you work. The corporate list here. Give me all the ways that you use information. If there's anything that you hear that makes you think, oh yeah, I forgot about that, write it down. Okay,
Pen and paper.
pen and paper,
Computer.
computer, text messages,
Office Ally,
Office Ally, billing program.
Availity for Blue Cross Blue Shield, I think you use that.
Yes, that's all electronic, isn't it? Mm-hmm.
No.
Email, absolutely. How about fax machines? Do you scan and email anything? Or scan and fax? Do computer faxes or fax machine, either one? Okay,
So if we put a diagnostic code in a receipt on a billing program, that counts as client privileged information,
yes, it
right?
does. If you do that, you're HIPAA mandated.
There you go. I found
All right.
I found 5 digits
Good.
that I have to deal with.
Any of you on Psychology Today?
Yes.
Yes.
And you get emails from clients through Psychology Today? That has to be listed. Any of you have a website
Yes.
where you get emails from clients through your website? That has to be included in your considerations.
Phones.
If you do any communicating with clients through social media,
You should stop it right now.
Yeah,
What are you thinking?
Friend
you
request.
have to list that here for consideration. That's all I'm gonna say about it for right now.
Do you have to
If
list
you do that.
phones? Because we don't have phones yet.
Actually, phones are not covered by HIPAA
Because they're not stored.
in security. They're not covered in the security aspect of HIPAA because they're not considered electronic.
So doing like an hour
However-
of phone therapy is
kind of the
okay.
telehealth stuff.
Now that's, see, here's the thing. In terms of HIPAA, there are regulations for that. There are also numerous ethical and legal mandates for everything that's telecounseling. Phone, Skype,
Text.
distance, text, email, all of that.
Okay.
It should be considered. It's not specifically security, but it's part of HIPAA. Oh my gosh. Also, it'll come back, whatever it was that I was going to impart to you. So, from this list on this page, go to the next page and put everything from your list in the first column that says asset. So everything that you use for client communications and information goes in this column. It's a little small. Might have to write small. And I will make these forms available to you all in digital format. I'll email them to you so that you can copy and paste them. do whatever you need to. So, list. Let's go ahead and talk about the rest of this. If you didn't get everything listed, you can do that at home. Let's go ahead and talk about what else has to be done. The next part of this is your actual risk assessment process, from which you're going to determine an overall level of risk for each of the things that you do with your pets. Okay? Goal is for all of us to know where our risk points are, and then to have some written information about what we do with it. Okay. First column, level of vulnerability. Think about cell phones for a minute. And we didn't say that, by the way. Many of you use cell phones for email or for texting?
Yes.
Okay, then that goes on your list. Cell phones are very vulnerable because everybody loves them, everybody wants them, and they're easy to lose. I know people that have had them fall in the toilet. So that's vulnerability. How vulnerable is my equipment or my process? We go low, medium, or high. Next thing to consider, what is the level of threat? So, if I have a cell phone from 1995 that's this big that I use, and it has the vulnerability of getting lost or misplaced, the threat for that is a lot less than the threat for my iPhone that I have, because a lot of people want cell phones and nobody really wants my 1996 big Trojan horse cell phone. Okay, so what's the threat?
Is this low, medium, high, or?
Low, medium, high. My computer my desk computer that I use in the office, it's at least 10, if not 15 years old, and those aren't worth anything at all, and they're kind of hard to steal. So the threat to my desk computer is pretty low. If it were kept out in the hallway, the vulnerability would be really high, because anybody could come along and take it. The threat would be low, because nobody really wants it.
In our HIPAA recorded,
Yeah.
assessment,
Yeah.
do we put sentences about why we determine the level, low, medium, high? Like,
This actually serves as your documentation.
we don't have to say it's in my office and there's 2 locked doors and blah, blah. We don't have to say why we assessed it at that level.
No,
We
you don't
just
have to
say
provide that
I'm
much
in the-
detail.
okay, gotcha.
You just have to make your determination,
Mm.
and then they can ask you how you came to it. Mhm.
So subjective though.
Oh, everything's subjective. It's true. Okay, vulnerability, threat. We are now at step 4. We're going to combine threat and vulnerability to give us an overall likelihood. So the likelihood of my desktop computer getting stolen is low. Even though the vulnerability is high, the threat is low. And so the overall likelihood is low.
So I have a question. So any electronic form, would you say, is high in terms of vulnerability? Just by nature of it being electronic communication? So
I'd say
email,
anything other than
a
a
large old
dinosaur desktop.
still high vulnerability, low threat.
Well, the threat depends on how much is it wanted. But I can't think of a
The
device
equipment
that-
itself?
The equipment itself,
Okay. The cell phone would be high.
Cell phone would be high,
Laptop computer would be high.
yeah.
So if we put down psychology today,
then the threat would be low.
Yeah, because who's going to go to Psychology Today and try to hack into the system so that they can get an email that may have a person's name and phone number? What people want, what the identity theft people are after is social security number, birth date, address, phone number. Mostly social security, because with that, you can create anything else. So when we're thinking about threat, that's a piece of it. With your Psychology Today, there's no social security number, probably not an address usually in that first email. So the threat is lower. Psychology Today encrypts their website. Now, here is a takeaway point for all of this. Even if the threat is high, encrypted systems have low vulnerability. So they steal your laptop, it's full disk encrypted, no vulnerability because they don't have any access. So likelihood, first consideration. My cell phone is encrypted. My cell phone is password protected. I have an app that automatically wipes out my phone if it's lost. And the app's in my iPad and in my computer so that I can remotely wipe out my cell phone if I lose it or it gets stolen. Those three things make the vulnerability of my cell phone really low. So even though the threat is high, the vulnerability is very low, and that's an overall low likelihood that a breach will occur. Make sense? Good. Next thing to consider is how bad will it be if a breach does happen? Think about how many Blue Cross Blue Shield subscribers there were when that was hacked into. And that was a laptop. That was somebody's laptop. They got stolen. That's how that happened. We've heard about the recent government employees information that was accessed. That's not a HIPAA violation. But think about all of those people. That happened because the only protection was a username and password. That was the only protection in that system. Okay, so how bad is the threat? Those two cases are a very severe threat. Person's going to lose their identity. They're subject to all kinds of ramifications as a result. With my voicemail system, somebody leaving a message on the wrong extension is not a very severe occurrence because the person's going to get it as a therapist. And they're going to give it to me and then or to the other therapist, and it's going to be destroyed. So that severity is very low. Finally, when we combine the likelihood that it will happen with the severity if it did happen, we get the overall level of risk. And you want to do that for each of the things that you do. I know. You know, I think maybe that we should all have HIPAA parties or, you know, how we do Tupperware parties and enjoy parties and whatever else everybody's doing right now. Have a HIPAA party and just do all this stuff, crank it out. Making sense so far? This page serves as your documentation for your risk analysis. Next step, actually this whole document serves as your record of your risk analysis, not just that page, the whole thing. Step 3, what are you going to do about your overall high risks that you discovered on the previous page? Suppose I was keeping my computer out in the hallway. I might say that I would keep my outside door locked at all times. I might say that I would chain it to the floor so that nobody could come along and pick it up. If you have something right now that's not encrypted, you can say, I will get encryption software for computer, laptop, cell phone, etc. Okay? When are you going to do that? And how are you going to do it? Those are your 2 things to consider.
With something like a phone, say texting or accessible emails from the phone,
Yeah.
would an example be to print somehow those texts and emails, put them in the records, and delete them off the device?
Yeah. So you can say, at the end of the day, every day, I print out text messages, then I erase them from my phone and put them in a locked file cabinet. Okay.
Can you print a text message?
I don't know how to print a text message. Do you know how to do it?
There's a
You
way.
can screenshot it and then print
Email it.
that like it was a picture, because a screenshot goes into your pictures, right? And might have a few screenshots.
I think you can also forward a text to your email, print it that way.
It probably depends on your
System.
phone, your system.
That sounds like
More,
Vulnerability.
yeah, more vulnerability.
Do you have to worry about like, so clients may, their numbers are in under their first name, last initial,
Uh-huh.
and then I don't have conversations over text messages. I have, you have an appointment, reply yes or no, and then, okay, well, let's reschedule here or let's reschedule there. If people start saying, oh, well, this is going on and this is going on, I'm like, yeah, it's not appropriate to have this conversation. You may call me, or you can call me at this time, or we can talk about it, but we're not gonna have a big discussion over text messaging because I can't protect you, is what I tell them. So I don't have those. Do I have to like document and stuff each time that I send a text message to remind somebody they've got an appointment?
Tell you what, let's put that on hold.
Okay.
And we could go ahead and do this, but when we're considering security, we have administration, we have, yes, right, physical security and technical security. We have 3 things to consider. Right now, we're doing administrative stuff. We're going to talk about the technical protections when we get there. So if you don't mind. Sure. Everything's connected, and it's all good, but let's, for the sake of trying to keep our minds somewhat
But it's
oriented.
too late for that.
Okay. Administration. These are things that are required for us. And guess what? There's another form. It is on page 37. What we've just done is to assess risk for what we do. On page 37 is a checklist for our entire HIPAA organization. Okay? So this covers all parts of HIPAA that we have to consider. I like checklists because they're easier than having to write words. So this checklist allows you just to check off all the different things to consider. Number 1, designate a security officer. That would be us. If you're a solo private practice, your security officer would be you. If you're in a group, who's ever in charge of the system for your group practice is your security officer. Or you could appoint your IT person to be your security officer if you're going to hire that person. But you have to appoint them. Then you have to let clients know that you have a security officer, who it is, and how they can contact them. So, first thing on the form, identify your privacy officer. This part, the administration part, talks about policies and procedures. In larger organizations, policies and procedures are really important. If you have 25 staff members that are handling patient information, you need to have written policies and procedures that are very clear about all of that. For smaller practices, you could elaborate, if you wanted, on the risk analysis form, make some additional notes, and that can serve as policy and procedures. The most important part is that it is in your mind and there in how you play that out. Okay? Workforce. Business associates are very important. And as of 2013, business associates can be fined and imprisoned equally to providers. So every one of our business associates has the same level of liability and enforcement that we do. A business associate contract is required with every person who works with us and handles protected health information.
Do you have a copy of that in the forms packet?
Yes, it is. Page 34. In the interest of time, I don't want to go through all of this in the business associate contract word for word. The important thing is that we, as the privacy officer, or as the owner of the practice, whatever that is, are responsible for training our business associates in the protection of health information. So we have to be sure that they understand everything we understand
Are
about what's
independent
required.
contractors considered business associates, or are they considered employees that would sign a confidentiality agreement?
If they have access to any patient information, then they're business associates. If they don't, then they're not. Yeah, so if you're in a building and you have an office and another person has an office and you're both independent contractors and neither one of you has any information about the other person's clients, then you're not business associates.
But if we share a phone
If you-
or something like that, then you are?
Absolutely.
Okay.
Mhm.
What if you are just like sharing the copy machine, the printer?
If you can see or handle any of the patient information for your colleague, then you're business associates.
Okay.
I'd have a business associate agreement, even if it was an independent contractor,
Okay.
just because
You just
things
never
do
know.
get commingled. And better safe than sorry.
We have a good question. She just said I should ask this. You ask it.
So, we have a shared, we don't have a shared phone. Stacy has a phone where people can call and she can refer out
Refer to our group.
to our
But
group.
we're all private practice individuals.
Okay,
Nothing else is shared, nothing is shared. So it wouldn't be a business associate, would it?
yeah, it would.
Because I
Because
would know
the
a person's
information-
name.
Gets transmitted from Stacy to everyone else.
So is that the same then if you get a client and you refer to somebody outside the group?
No,
Oh, if it's true.
no, that's not a HIPAA consideration because it doesn't deal with client information in your agency or in your practice. There are ethical and legal considerations about that,
Uh-huh.
but not HIPAA,
Only if it's within.
only if it's within the same structure where you're sharing information systems. Because every one of your therapists uses your phone.
No.
No, but
Oh.
let me finish my sentence.
Oh.
Every one of your therapists uses your central phone line as the way that they get referrals through the practice.
And through the email on our website.
Right.
They can email
Right.
us and.
So you're sharing patient information. Thanks, SJ.
Thank you, sorry.
If you have a second to do the evaluation and email it to me, that'd be great.
I will do that.
Thank you.
Bye, guys.
Does that make sense?
Mhm.
Yeah. So it's the protected health information that's the key. If that gets shared in any way, then a business associate contract would be required. Thing we haven't talked about yet is sanctions. You have to have a system of sanctions if a business associate messes up. Mine is grounds for being fired. So my assistant receptionist knows they lose their job if there's any kind of breach. I'm very aware that the staff members in the medical office that took the information and sold it underground in the IRS scandal undoubtedly had the same training and the same sanctions and did it anyway. So it's not a guarantee, but it's our due diligence to put those structures in place.
So,
And that's in this sample business associate contract.
so, like the person that's renting an office from me is not a partner, but is still a business associate because they'll definitely be using my printer and stuff for faxes and I can run into stuff. What kind of sanctions do you do for that? I mean, because you signed a lease with them too.
Well, you
So
you
it's
put
like
it
if
in-
you
but
screw up,
put it
your
in
lease is null and void.
Yeah.
I haven't
Yeah,
done
that's
the
what you
lease
do.
yet.
That's what you do. You say,
Okay.
the arrangement is terminated. Should any violation, and you could include an ethical or legal violation,
Okay,
occur.
okay.
You make that consequence spelled out right in the agreement.
Yeah, yeah,
Because I'm taking on a
Yeah.
new intern,
yeah,
so I would definitely have her sign the
definitely, yes. And be sure you provide training
It
also.
would be just for her, it would be just me going through this.
Mhm, yeah. And the training has to be updated. This is not a once and forever thing.
Well, that was my
Unfortunately.
next question, how often do you have to do this risk assessment form?
Anytime you change anything with your structures, then you have to re-evaluate that aspect of your risk analysis. And this should be done once a year anyway. Lisa says never change. Yeah, I'm with you.
Yeah, just don't change it.
We keep it the same.
Clients to change, but.
All right, business associate contract. So you want awareness and training, all security incidents addressed with protocol. Oh, contingency plan, we didn't talk about that. What are you gonna do in case there's a power outage?
Go on. No.
Is your computer protected in the event of fire? What if there's a tornado? So you just need to write some sentence about, this is the plan, should a tornado occur.
And what if we pass away?
Oh,
That's part
Well,
of it.
HIPAA actually requires that we have a practice will,
yes.
and that is a whole complicated procedure in and of itself.
Yeah.
I don't know, I'm kind of seeing weekly HIPAA parties.
With bottles of wine.
Yes. Trying to stay compliant.
So with the contingency plan, you're saying we just have to write out, because there was a building that burnt down here in Loveland with several private practices, and everything burnt, gone.
That's right.
There's no,
That's right.
because it was all
Yeah.
paper, right?
So you'd want to say, all the information was backed up. The information was kept in a fire safe, you know those file cabinets
Yeah.
that don't burn in a fire? They cost a lot of money, but they don't burn if there's a fire.
Oh my God.
Actually, I just picked up a little tiny one that fits a file
Uh-huh,
for $50, and it's fire and water.
yeah, that's not gonna store all your client
Yeah, I was
files.
like,
But yeah, that's what we're talking about.
Yeah.
So just some consideration for what if there's a fire? What if there's a flood? And that, part of that depends on how things are stored. If my records are in a cardboard box in my basement, that's not protected by a flood. So I don't do that. I hope you don't do that.
If you had it backed up,
all mine are paper, so
Yeah.
I don't have anything electronic. I mean, the actual client files, you know.
You know, I think it's not a bad idea to go through client files, photocopy them, and keep a separate place for at least the recent ones.
That's unreasonable.
Okay. Don't do it. Don't do it.
Really?
Oh my goodness.
Could you go through the file and like, you know, just scan it all in and have an electronic file?
yeah.
Well, you can do that and then back up your computer.
We have to keep our files for 7 years.
Yes.
right? After that, we can destroy them, we don't have to
That's
notify
correct.
anybody.
That's correct.
And it's right in my disclosure or my,
Yeah.
that they will be destroyed in 7 years.
Okay.
And then do we shred them or do we get to set them on fire?
That's up to you.
Okay, all
All
right.
right. Okay, so let's see where we are here. Last thing to talk about here with administration. Periodically, once a week, once a month, you need to have some system for accounting for how the information was transmitted or communicated in any way.
Once a month.
Yeah, well, at some point. Some way to keep track of your system. That's a little tough to do, right? Tracking of that. Most of the all-in-one printer, scanner, fax machines do that. My computer, the main computer, has a separate login for everybody. And then the computer tracks when each person logged in and how long it was. And that's all stored in the computer. This is where an IT person, really, I just would be so overwhelmed trying to deal with all of this without any kind of tech
So
support.
doing like a fax cover sheet with the date and the time even doesn't count?
Oh, sure it counts,
Oh, okay.
sure.
So in paper, it's in paper.
But they're, yeah. Mhm. So you just want to think about how you're going to be able to go back at the end of the month and pull through all your transmissions that took place. Hire an IT person.
Stamp or write the date after I
Yeah.
send it,
Yeah.
so that's okay?
Good. Mhm. Okay, so physical protections, we've talked about that some. Be sure your equipment is nailed down, be sure it's kept locked up. Don't leave your laptop in your car without locking your car. And don't leave your laptop in your car where people can see it and break into your car. Physical safety. Pretty self-explanatory. Notice everything that is addressable here These are things to think about, the things that as small providers, we're not as invested in. Facility access controls. Nobody is gonna come into my office and sit at my computer, because if the door is open, I'm sitting at the desk with my computer. If I'm in a hospital and I work at a desk and I go to the bathroom, who can come into my office and get that computer? Lots of people. So the hospital has to really consider all of this stuff. Us, not so much. That's why it says addressable as opposed to required. So workstation use. Be sure you tell everybody that works with you or for you how to protect client information when they're sitting at their desk. That includes closing the door if you're talking on the phone to a client. It includes not saying, "Oh, hello, Mary Jones," when you walk into the waiting area and your other therapists have the door open if you're in a group. Okay? There was a HIPAA lawsuit that happened because the receptionist was on the phone with a patient, first and last name, talking about the diagnosis, talking about the surgery in this waiting room full of people. Don't do that. A couple of things are required here. This is still physical safety. If you're going to get a new computer, make sure the one you have gets completely erased. And deleting a file does not erase it from the computer. Right? It has to actually be wiped out. That's another good reason for an IT person. So disposal, media reuse. If you keep information on a disk or a thumb drive, be sure that it gets taken off of there before your thumb drive gets used for sharing a PowerPoint. Accountability and backup. Yeah. All right, technical stuff. Again, an IT person is most helpful. We haven't talked specifics about text messages or about email yet, and I think we want to do that. There are some necessary protections in that regard. Text messaging, let's start with there. How many of your clients want to use text messaging?
All of them.
Yeah, pretty much universal. Yes, it's become so much a part of our everyday life. Text messages are not secure. That is a huge vulnerability when it comes to text messaging. And that's true in a couple of ways. They can get accessed because I send a text message from my phone. Who knows which tower it's going to go to or where it's going to go, and there's going to be a bunch of stopping places between my phone and the recipient's phone. Any number of those places can get hacked, so it's not secure. There are a few things we can do, however. One of them, iPhones, the text messaging for iPhones is automatically encrypted. So if I'm texting from my iPhone to someone else's iPhone, it's encrypted both places. That adds to the security, but there is still that in between. It's encrypted in my phone, it goes out there, who knows what happens. It gets into their phone and then gets encrypted. Other smartphones have different levels and degrees of encryption and security and all of that, so you just want to check with whatever cell phone carrier you have in that regard. I mentioned the app. My phone's in my purse. It's called Find My Phone. It costs $9.95 a month. It also will locate your phone. I haven't had to use this. My husband loses his phone all the time, all the time. And so it'll make a sound, your phone makes a sound, and then you can figure out where it is. Or if I would leave it at the office and I'm at home and I don't know where it is, GPS will show on my iPad that my cell phone is at the office. It'll give me the office address so that I can locate it. That app includes automatic remote wipeout if I choose to. Suppose I lose my phone or it gets stolen. I go into my iPad or my computer and say wipe out my phone, and it does. Email.
Can I ask a question?
Absolutely.
So, if we decide to use text with what you described, would we just want to include in our disclosure that, you know, if you, as a client, if you decide to text, just know I'm encrypted and whatever your phone is what it is, and whatever the tower is, that this is your risk. And if we just say that, then that's our responsibility and we're good?
There is a form. There is a form that actually HIPAA provides or specifies for us to use. And it's on page 21. This is a consent form that clients can sign. And if we are going to use text messages or email, we have to have clients sign this form.
So it's
Because
not
we have
it
to-
in our disclosure, because I have a separate paragraph for that disclosure.
According, and this is where things really get complicated. We have a separate disclosure statement for the state of Colorado. And we have a disclosure statement for HIPAA. There's a lot of overlap, but those things have to be in both places. Okay?
This is a HIPAA one?
This is the HIPAA required, yes. And so we have to inform clients that text messaging and email are not secure means of communication. Then we have to give them the choice about what they do. They can authorize the use of text messages and email as long as we informed them that they're not secure.
And them signing this is
That's it.
That would replace the form that I have that you saw about email and texting. Do you remember that?
Is it in your disclosure statement or is it a
it's
separate form?
one. I'll just
Actually,
replace it.
that form would work.
Okay,
It needs to be a form
okay,
that says, I understand email and text are not secure.
okay,
I give authorization to use those.
okay.
Okay? So that's what you'd want to show HIPAA if there is ever any problem that comes up. Okay? I want to be sure that I tell you about secure email. There are secure email programs. One of them is called Hushmail. That's a program that I use. It's encrypted, for one thing. Secondly, when I send an email to a client, the client is required to answer a security question in order to open the email. I would communicate to the client what the answer to the question is. Another problem with email is not authenticating the user. Suppose I send an email to a client and it's actually her abusive husband that opens up the email. That's one of the ways that email isn't secure. This solves that problem. I send the email to my client and the password is Azalea. Her batterer tries to open it, can't open it because he doesn't have the word. Also, once the person enters the word, they can be registered so that I can send them additional emails back and forth. And I don't have to go through it every single time with every single client. That costs about $10 a month, and there are a lot of those programs that are available.
If you have Microsoft Office and stuff like that, you can lock your document and send the password based on that,
Yes.
like in another
Here-
email or something.
And so passwords are the next thing we want to talk about. As in the case of the government, passwords are easy to hack. There are tons of programs that hack passwords. So the passwords are not considered to be sufficient protection because of that. But yeah, I think it's worth doing. Password protect your documents. And the programs that cost like $40 to crack any password. So,
I said, just tell your clients, if you have a problem, call me. They'll call you back.
yeah, really.
Don't email me,
Phones,
don't.
in person, those are the ways we communicate. I do want to mention, let me think for just a minute here to make sure. Try to keep this somewhat linear so that it actually makes sense. Technical secrets. Make sure, so user identification is required, meaning, that's us, meaning before anybody gets into my computer, there has to be a password that's entered. That's user identification. Emergencies, we talked about that. Automatic log off, that's a good thing if you have a group computer. Ours logs off after 10 minutes. So my receptionist is at the front desk. She is working, she gets up, she answers the phone, she goes back to another person's office to say something to them. She ends up in conversation with them. There are people in the waiting room. They can't step up because the computer will automatically log off after a short period of time. That's addressable, not required. And encryption and decryption, not required, but they make life so much easier. Because my cell phone is encrypted, because my computer is encrypted, there's no or very limited risk that protected health information is going to get breached. And it's software that just lives and does its thing automatically. The backup software backs things up automatically. Mine goes Monday, Wednesday, Friday, 2 o'clock in the morning. And you can set that time. That happens to be a time that I'm not working. But if you wanted to make it 10 o'clock, you could do that.
What's the name of that software?
Actually, that's part of iDrive.
Oh yeah,
In the
okay.
cloud.
Okay.
That's cloud backup. And that is encrypted as well.
Okay.
Okay, let's just make sure we go along here. Personal authentication, we talked about. Transmission security. Good. All right, we got it. Let me say a few more things about what's in your packet. Look at page 4 for a minute, please. This is not security per se, but we all have to have the notice of privacy practices from HIPAA. Along page 4. Keep going. It's in the packet section.
Oh,
There's a blue cardboard. There you go. And then it's on page 4. So you all know that you have to give clients the notice of privacy practices, and that is separate from the disclosure statement. You have to give clients both of those. The OCR has developed a couple of new formats that I think are much better for the NPPs. The first is an outline, much easier to read. So that's the first thing in your packet is the outline form for the HIPAA privacy practices. They also have created a full color version. It's much more user-friendly. See, isn't that much prettier and artistic?
Oh, nice.
These are available if you go to the OCR website. The privacy practices forms are available on that website, and I put them on your resources.
So if we were to email a PDF or a link to the client, a new client, with this, is that sufficient, or do we have to give them a paper copy of the thing? Of the HIPAA?
You do not have to give them a paper copy of it, but you want to have this form that says acknowledgement of receipt of notice of privacy practices. That has to be in their file. But you don't have to actually have the form in your file. Just this that says you gave it to them. Yeah, I know a lot of people like to mail the forms ahead of time, so people have time to read them and not take them one at a time.
Yeah.
But just be sure you have this. So that's the next file, next item in your packet is this acknowledgement.
So what happens if they refuse to sign the document?
You just say they refuse to sign. See down there at the bottom, it says patient refused to sign.
Is that from the other services?
So clients have the right to request a change to their record. If they don't agree with what's in their records, they can request that we change it. We can deny that. So there are forms for the client to make the request and for us to make the denial. If we don't think it's in their best interest, or if we truly believe that the record is accurate, then we can say that. We can deny patients access to their record, again, if we believe that it would be harmful to them to have the access. And there's a form for that, if we're going to make that denial. This is the account of disclosures form, where we write any incidents of disclosing health information to anybody else. So, if I, as in the case of the disability people where I sent the record over to them, I would just make a note here. July 15, 2015, fax record to SSI. And then that goes in the client file.
Is this a required HIPAA form, or can I do this on my fax cover sheet, blah, blah, blah?
As long
Is
as
this
you have a
required?
record of it and it's
Oh.
part of the file, it doesn't have to be that
This
form.
one, okay.
It's just, if a client says, so who have you given my information to?
Oh.
That's a
we
form
need
where
to
you
know.
can
Yeah, yeah.
write it all out. This is a complaint form in case the client has a complaint. And with these forms, the notice of privacy practices has to be presented exactly as HIPAA says. The rest of these are at our discretion. So these are just samples,
Okay.
except the NPP. That is exactly verbatim.
So that's why you said it's nice to have a color copy.
I think it's easier for clients. And most of my clients don't even want to read it.
Mhm.
They sign it and they're done.
Right.
So this is the consent to use email and text message. I like this communications policy. This is not required by HIPAA, but I put it in just because I like it. Because I find that clients have expectations, such as if they send me a text message, then I should text them back within 5 minutes.
Right.
So I think it's helpful to spell out, this is how soon I return phone calls, this is how soon I can get back to you if you text me. Text messages are not a good emergency contact because, I'm sure you've had this happen, somebody sends a text message, I don't get it for 3 days, for who knows what reason. So I just think it's really good to spell everything out ahead of time.
Especially for Borderlands.
Absolutely. And others. So, I hope that's helpful. All of those are client-related forms. The next section are your administrative HIPAA forms. To try to help to make the work a little bit easier. The risk assessment form we worked with today. Your breach assessment form in the event that something happens. Hopefully it won't. Sample business associate contract. The compliance checklist is everything you need to know and do about HIPAA. This would be a great place to start for you to understand where you are with all of it. And I included a wonderful social media policy statement. I think this is one of the best I've ever seen. It includes how she handles everything. Facebook, Twitter, LinkedIn, websites, emails, text messaging. My general approach when it comes to social media is I don't do it. Just too complicated. But you each have to do what's best for you, and as long as it is clearly spelled out to clients and follows those ethical principles of the best interest of the client, and you document it, that's what's needed. Resources. I put some other resources on the resource list that I just sent around to you, and I wanted to mention those. The book, HIPAA Plain and Simple, is over there on the table, and you're welcome to take a look at it on your way out. Everything you need to know about HIPAA all in one place in that book. There's a HIPAA survival guide for providers. It costs $79.95, but it's a really good resource, and it's available from DHHS. By the way, there are tons and tons and tons of HIPAA compliance organizations and resources and things that cost hundreds of dollars. We don't need them. So I'm hoping that these resources are accessible. And then the next one is a survival guide that actually costs nothing and is available from the OCR. There's an online course. I don't know if you've ever heard of the Zur Institute. Great online courses. And so there's a HIPAA course that's offered through the Zur Institute in case you love this so much and want to learn a lot more about it. That's the way to do it.
Can I offer a resource?
Absolutely.
There's a website, or there's a guy named, his name is Roy, from Person Centered Tech. And I got his name, his contact name, Tamara Suttle. She's all things private practice, and it's just a good, really good resource. Oh, there you go. Is that?
It's an online course.
Oh, yes. So.
It's through the Zur Institute, but it's him.
Oh, okay. So he has his own website, his own services, and he's a therapist, and I don't know, I've learned a lot just reading his blog and getting his emails. So it's Roy from Person Centered Tech. Yeah. It's just
Good, thank you.
I have 2 questions.
Yes.
I know this is an ethical question, but where would you recommend that we could go and look at if our mandatory disclosure is like up to date, you know, or to just.
The DORA website
Okay,
has a model disclosure statement
okay.
on it.
Okay. And then my other question is, I may have misunderstood this, but I got the impression that when we were talking about texting and like having the clients know their risk factor and the negative side, I got the impression that wasn't sufficient for email as well. That somehow we needed to do something more with email to protect than just letting the client know their risks, and is that
It's a
right?
great question.
Okay.
In terms of HIPAA, the only requirement is that we inform clients and give them the choice for email.
Okay.
In terms of what's in the best interest of the client, I think most of my clients don't realize what they put at risk with their email, especially in regard to relationships and employers and all of that. So I might think it's not in their best interest to do it, even if they would say, oh, fine, no problem. But that's an ethical question and not a HIPAA legal requirement.
Gotcha.
So you still want it on paper?
Yeah,
Okay.
whatever, whichever way.
Okay.
There's an evaluation form, if you have a minute to fill that out. I love your feedback, any and all feedback that you might have. If you don't want to take the time to do that, I know we're a little behind. If you could fill it out and email it to me. It's in your green folders, the evaluation form.
I gotta take my battery.
There is a certificate in there as well. And so this qualifies for 2.5 hours towards your professional development for LPCs. So, you're welcome.